it's Brittany Kuhlman. Today we are going to be talking about parents' rights within special education. This is for the state of Kansas as well as for Garden City Public Schools. Today we're going to be talking about the procedural safeguards from Chapter 1 for the Kansas Department of Special Education. The topics covered are going to be parent participation, definition of a parent, parents' rights and special education notice, prior written notice, parent consent requested but not provided, notice of IEP meeting, rights for parents of gifted students, education advocates, and student rights at 18. We're going to dive right into parent participation, but if you feel that you need more information, please visit www.kdse.org, Procedural Safeguards, Chapter 1. All right, so first is parent participation. Congress has mandated that schools afford parents the opportunity to be members of any decision-making team for their child. This includes eligibility for special education, evaluation and reevaluation, and the development of IEPs. Parents are to be provided notice of meetings related to the eligibility, evaluation, reevaluation, and development of the IEP related to the Free Appropriate Public Education Act. Next to discuss is the definition of a parent. Not every student has the same home situation as you might have had. So let's dive into the different types of parents that we could be seeing. All right, so our school personnel must determine the appropriate persons to make educational decisions on behalf of the child. In Kansas, a parent is defined as either a biological parent, an adoptive parent, a person acting as a parent, legal guardian, officially appointed education advocate, or a foster parent. Let's dive into a couple of these different options. So a person acting as a parent could mean a grandparent, a step-parent, or an other relative with whom the child lives. They must be legally responsible for this child. If the parents are divorced, the school must provide notice to both parents regardless of custody unless there is a court order. If one parent denies consent, the other consent from the parent is sufficient. The next topic is parents' rights and special education notice. So our schools are required to provide a copy to the parent about their rights in special education. They are required to do this at least once a school year upon request for evaluation or reevaluation, first formal complaint or due process complaint for that school year, upon disciplinary removal from the school that constitutes a change in placement, or upon parent request. Our next topic is going to be written prior notice. So us as school districts, administrators, we need to be able to be giving these families ample amount of time to be prepared for these type of meetings. A good amount of time is considered to be 15 days. So let's dive into written notices. So a prior written notice is a notice of certain proposed special education actions. Again, we must be able to provide that within a reasonable amount of time before the date the school proposes to initiate the chance of either identification, evaluation, education, placement of their child, or provision of special education and related services. The prior written notice should contain a description of the action proposed or refused, an explanation of the school's proposal or the refused action, a description of each evaluation procedure, assessment, record, or report the school uses as a basis for proposed or refusal of the action, other options the IEP team has considered and reasons why they were rejected, a description of any other factors relative to the proposal or refusal, statement that the parents have parental rights under law, sources for parents to contact to assist them in understanding their rights, and then if the notice is to conduct evaluation, it must describe the evaluation procedures. We as educators just want everybody to understand what's going on. So if we can provide that written prior notice to our parents, then everything will run a lot smoother. Next is parental consent. Now this could get us into some sticky situations, so let's make sure we pay attention. Federal and state statutes and regulations have specific requirements for requesting parental consent. Consent is always to be an informed consent. That prior written notice must accompany the request for consent for each proposal of special education action, and the parent must agree in writing for the action which they are consenting to. The following actions require parental consent. So to conduct an initial evaluation or a reevaluation, the initial provision of services of IEPs, making a substantial change in placement, more than 25% of the child's school day, to make a material change in services, to add a new service or get rid of a service, consent to excuse an IEP team member or team meeting, to invite an outside agency, the use of Medicaid, or the use of private insurance. Now, we can provide an electronic document for consent, but it has to follow 3 conditions. The document is going to identify a particular person as the source of the electronic consent. It must authenticate a particular person as a source of consent, and it must indicate such person has been fully informed and approves the information contained in the electronic consent. All right, the next topic is parental consent requested, but it's not provided. So the school must make reasonable attempts to obtain consent from parents for each special education action as required. Again, reasonable attempts are going to be defined as at least 2 contacts by 2 different methods, and we need to make sure that we are documenting those attempts. That should include records of if we've made phone calls, and the results of those phone calls, copies of written correspondence that we have sent to the parents, as well as if we've made any home visits. We need to remember that parent consent is voluntary, so they can revoke their consent at any time. If they do choose to revoke their consent, it must be in writing, and when parents revoke their consent for a specific special education action, that revocation is not retroactive. It will become effective of that date or the future date that it is indicated. All right, so notice of IEP team meetings. The school must take steps to ensure that one or both parents are present at each IEP meeting or otherwise afforded the opportunity to participate. So it could be over a conference call or a Zoom meeting. This meeting should be scheduled at mutually agreed upon time and place, and it must provide notice to the parents at least 10 days prior to that meeting. The written notice must indicate the purpose, the date, the time, location of the meeting, the titles or positions of the people who are going to be within the meeting on behalf of the school, and the parents have the right to invite an IEP meeting individuals that they think will be expertise for their child. If their child was previously served in Part C, parents may request that the local coordinator or other representative can be invited to participate in that IEP meeting as well. Our next topic is rights for parents of gifted students. So an exceptional student is considered to be a gifted student or a student with disabilities. Now, our gifted students do not get all of the requirements and considerations that the special education students get. All right, so our state statute also includes categories for gifted children. So in that state statute and regulations, the term exceptional children again includes children who are gifted and children with disabilities. So special education services are not compulsory for children who are gifted. Those parents of gifted children may choose to accept whatever special education services are proposed, but they can also deny them. So parents of and children with giftedness who do not also have a disability, they have the same rights of parents and children with disabilities except for these following exceptions. So the first one is the disciplinary protections of children in special education do not apply to those who are gifted. You will not qualify for special education services or gifted services if you are under the age of 5. Students who are gifted do not have the same considerations for least restrictive environments as students with disabilities. Students who are gifted are not eligible for all related services. For example, extended school year services are not provided. Students in JJA, the Department of Correction facilities, do not receive gifted services, and then requirements for secondary transition and summary performance are not applicable. Our next topic is education advocates, and we've already kind of talked on them a little bit, but let's really dive into an education advocate and how they can help our students. Okay, so an education advocate is referred to as a surrogate parent. So they are appointed to act on behalf of the child when the parent is either unknown, unavailable, or their parental rights have been severed. The state of Kansas actually partners with families together to provide those educational advocates to children. A person appointed as an education advocate for a child should not be an employee of the agency, which is required by law to provide special education or related services for that child. An employee of the state board, the department, or any agency which is directly involved with providing educational services, or a person having a professional or personal interest which would conflict with the child's interest. Also, in the state of Kansas, a foster parent may make educational decisions for an exceptional child only if that foster parent receives the required training and is appointed by the Kansas State Board as an educational advocate. The last topic we'll be covering is student rights at age 18. So on or before the student's 17th birthday, the IEP of a student must contain a statement that the student has been informed that at 18 they will become their own decision makers. The parental rights are going to transfer. Now, when there is a next IEP meeting prior to them turning 18, you must provide notice to the parents and the student of the meeting, but the parents are not entitled to attend the IEP meeting. All right, so a lot of information has been covered in a very short amount of time. If you haven't already, go to the KDSE website, go ahead and download the safeguards. You can save them to your computer, so that way not only are our parents going to be informed about special education rights, but we as a staff are going to be also.